right? Do you agree with that statement?
Yes.
Okay, so without actually having examined in your own personal observation how a scram device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Objection asked and answered.
Okay, just let's go.
Just answer the question. I don't know if that was an objection or sustained or overruled.
Let's just move on. I mean, we're here to see, is there a positive blow or not? She's testifying that there was.
Sure. I'm just saying that this, I'll make my argument in closing. I don't have any further questions. Thank you.
You know, okay, closing, or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if the scram device has been tampered with?
Yes, we get notified of tampers and consumption events.
And you get notifications if it's been cut off? Like, just what's been going on with the scram device? You get those notifications?
Yes.
Okay, thank you. No further questions.
Matt?
No further questions, Your Honor.
Okay, thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a scram device and for refraining from alcohol consumption and not tampering with the device. The defendant's scram device was reported on one consumption event. This happened January 16th of this year at 11:55 p.m. and this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated the order, was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the scram device is a device that can be detected.
Okay.
Yeah, Your Honor, I agree with State insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The State did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the State failed to prove their burden of proof that my client consumed alcohol. And I would ask that, Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just take into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say it again.
These devices are used all the time.
Well, their use all the time is irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
When we have the positive THC or stuff.
He had a positive THC, right?
Yeah,
As well?
that we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Here this week.
that wasn't, are we still on the record then? On the, okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself, on whether it tests cannabinoids, which delta-8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any delta whatever. Regardless, it's number 3, goes with you. Off the record. Sorry. Thank you. But I just can't, with an open DWI and a third, that's it. I can't just keep doing it. You know, at some point I become an enabler and I can't do that. I can't keep doing it, you know? So.
Well, I mean, Your Honor, I understand you revoked the bond. Would you consider raising it to?
Well, I am going to raise it, right? I'm going to raise it to 7503 now.
Well, and look, I'll just, if you could take this into account, Your Honor. This is a hired client. You know, he has every intention of taking this case to trial. So I would, you know, just, I'm not cheap, Your Honor. So if you could keep that into consideration on that.
It's, you know, and it's
I understand.
representing him in Navarro too.
No, I'm in touch with his counsel there, but no, I'm not representing him there.
Hey,
Yeah.
but tell him this, that he's lucky that he didn't revoke him on the first 2 cases, considering that he has an open, you know, really, because, and I'm telling you now, I don't know how I didn't, but I can't just keep doing it. I can't.
75.
7503. Yeah.
Judge, quick on this one. I should have called her up. She failed to appear on her,
Just don't worry about it. It's still.
or page 14.
And then hold on. I have a lawyer here, Mr.
Oh,